all levels. We are the first to use the American Bar Association model. So we're not the first municipal court to ever do this. We're just using that which is approved by the American Bar Association. And the American Bar Association model formed in the late 1980s in San Diego. Obviously, we are not San Diego, so it has been modified, and the American Bar Association provided free support for us to set it up. Essentially, how do you do it? How does it work? What are the intentions? The purpose of outreach court is to address the issues that lead to a criminal defendant coming into the system. Those are typically three major areas in our court. It's substance abuse, mental health, or housing instability. So someone can come to court perhaps with a trespass case. Realistically, they probably have 5 trespass cases because they're unhoused and they're going places they're not supposed to go. So if they say, hey, I want to get a housing voucher, I want to figure out a place to live, then we can accept them into outreach court. They will work with the Pinion Project, who is our hub. The Pinion Project has graciously and amazingly agreed to essentially help us with this project. There's no funding for this project. The city is not paying anything for this. We don't have grants. We buy Pinion Project lunch sometimes, and they graciously have agreed to do this. So they help organize the individuals to access the services with providers that already exist in our community. So Pinion Project is already doing housing outreach. That's what they do. That's one of the many things they do. So if someone comes in and says, hey, I really need to find housing, we connect them with the Pinion Project. They agree to work on that for 90 days, and they come back to court. And if they have done that, we dismiss their charges. If someone has restitution, they're not eligible for this program. So if they've caused, property damage or harmed someone else, they're not allowed to be in the program. But the intention is really to stop this cycle of people coming into court over and over and over again for trespass, for possession of alcohol in the park, for public intoxication related cases. We don't have public intoxication, but cases that essentially people are drinking in places they're not supposed to. We have had 32 people in the program so far. We've had 4 successful graduates. The program is designed to have an initial contact and then 90 days later come back and see if you've done what you've needed to do. We are seeing an increase in defendants requesting to come back more often. They want the additional accountability. They want to check in. They want to know that I'm going to be asking them, what have you done? And have you made progress? Pinion Project has sent about 10 people to inpatient residential treatment, which is huge. I actually was contacted by a deputy district attorney in Cortez and said, how are you doing this? How is the city of Cortez sending these people to treatment? And we're not. Pinion Project is helping them, and they're using funding sources that already exist. They're using Medicaid, Indian Health Services, insurance. So Outreach Court is really connecting people to services and programs that already exist. Access is already providing these services. The Recovery Center is providing these services. We are giving them a pathway to not just go to jail over and over again for the same type of charges. So I do feel like we are making a positive impact. I think that it's moving in the right direction. We just had an individual not only get a housing voucher, but become housed for the first time in a long time, and it's through outreach. If outreach wouldn't have existed, I don't think he would have been working with the Pinion Project. So I do think we are making positive impact in this community. The last thing that I'll say is I have worked in other municipal courts in various capacities. Our court works well. Like, it really amazingly works so well, and it's Miss Odell and Miss Petros. They are a well-oiled machine. I get my dockets ahead of time. It is not uncommon that if you come into court on a Monday morning, the prosecutor and the defense attorney are both talking to Miss Odell and everyone is getting along, and that doesn't happen with most courts, right? It just doesn't work like that. And because of the relationships that Miss Odell has made over the years, and because of her commitment to the people that appear in our court, people are willing to work for less than they could make, and they're willing to represent sometimes very challenging clients. And it's really because this court is working and what is happening in our municipal court is functioning. So everything is going pretty well. I know that was a ton of information. If any of you have questions, I'm happy to answer them.
Ms. Padilla, I just want to say that I really like the approach that you've taken. It's not solely punitive. And I think the focus on responsibility and accountability is really respectful of the person who's really made a poor choice. So thank you for working so diligently on that.
Thank you. I will be honest, plenty of people are getting bench warrants when they don't come to court, and that didn't always used to be a thing. Although our code says that they shall receive a bench warrant for failing to appear, I'm issuing them. Not always, but most of the time, right? If you don't go to court and you have a criminal case, that results in a bench warrant. So I do think, I don't know what the numbers are, but people are certainly going to jail through our court process. It's not all soft and fuzzy, if you will. Sometimes we start with a little jail sentence and then regroup to figure out what we can do to move forward. So it's sort of a multifaceted approach because diversion doesn't work for everyone. And some people don't want to do the program. And unfortunately, we've had some people that I've removed from the program. At a certain point, if I felt like they're not making progress, they're not committed to getting better, we just put them back on the normal docket, right? It's a voluntary program. They're not punished for failing outreach court. We just put them back with the normal criminal defendants, and they work through their cases however they're going to work through the cases.
I, too, want to thank you for what you're doing. I think it's an excellent program. I do, as I'll reiterate, I don't want to lose sight of our victims because a lot of times there's victims involved. I got a little question for you, though. Back in the day, if you were found guilty of shoplifting or you pled guilty to shoplifting, $300 fine, 10 days in jail. That was pre-COVID, and the justice system has changed a bunch, and they look a lot differently. Could you tell me, so I can tell our business people, what we expect if they call in a shoplifter and that shoplifter is found guilty?
Sure.
Or pleads guilty?
So I think it depends on the circumstances. Shoplifting does not have a harsher penalty typically than other cases in our court. And so typically you're looking at the 3 to 5 day suspended jail and often that's what the city attorney and the defense attorney have worked out as a plea deal. And so, we're not doing a lot of trials, right? Like we haven't had a jury trial in quite some time. So usually it's people reaching resolutions between the two attorneys. But I think a typical sentence would be a 3 to 5 day suspended jail, typically going to be community service. And if there's an allegation of alcohol or drugs, they're gonna have to do an alcohol evaluation. And then if there's restitution, they're obviously ordered to pay restitution. Oftentimes the shoplifting cases do not result in restitution because the items are recovered in our court. Not always, but that's certainly something I'm always watching for in the police reports before the cases are heard.
Can you speak about your recidivism rate? What sort of cases usually occurs in, what our numbers are out of those 430, something like that?
Sure, I can answer some of those questions. So recidivism rate, I don't know. And most of our case types, we're seeing a lot of trespass, especially in the summer months. We see an increase in people just being in places they're not supposed to be. Oftentimes it's people that have caused problems and a business or a homeowner has said, I don't want them here anymore, and a trespass notice is issued by law enforcement. So if someone were to shoplift, for example, they usually get a trespass notice. So then if they were to go back to Walmart or Safeway or Speedway, then they would pick up a trespass case. So we're seeing a lot of trespass. We see a substantial amount of possession of alcohol in the park, open container in the park. Traffic violations are all over the place, speeding, careless driving. But I would say most of our criminal cases are trespass and alcohol related. And I can't remember if that answered all your questions.
I think you tried. I have another question. How many of your cases actually result in jail time out of those 430?
Right. I don't have that number. I would say few. Well, it depends, right? So what we see a lot is people are ordered to come to court and they don't come to court, so I issue a bench warrant. Once they're picked up on a bench warrant, they're in jail typically slightly under 48 hours. So at the 48-hour mark, they must be released. They must be released on a PR bond with no conditions. That's the law. That's not my idea. That's what the state legislature says we have to do. So typically, we will have court Monday, Wednesday, and Friday to ensure that we're getting people in court to address bond and address their cases before they're just released. We're really trying to stop the catch and release process because that's frustrating for defendants, it's frustrating for law enforcement, it's frustrating for victims. So we really want people to get into court and address what they need to address. So if you take into consideration people that are in custody following a bench warrant, maybe this is a guess, I would say maybe 30 or 40% of them have some sort of jail, touching base with the jail. If people come to court and enter a plea and don't get in trouble again for 6 months, they're typically not going to go to jail. I have issued sentencing guidelines that I am inclined to do a jail sentence. I think it's a 2-day jail sentence on any indecent exposure with a child present, because I just think it's unacceptable for there to be that happening specifically in our parks. Rarely, when someone is charged with indecent exposure, do they plead on indecent exposure. Usually there's a modification of the charges, and again, that's at the request of the city attorney and the defense. They've reached an agreement. So I don't get to pick new charges. They say, hey, we have an agreement to plead to maybe disorderly conduct or something else instead of the indecent exposure. We do see the indecent exposures, not a lot. It's often highly intoxicated people urinating in the park. Sometimes near the playgrounds, sometimes near field trips, sometimes they're just not aware of what's happening. And so those are particularly of concern to me. I don't want to see police reports where mothers are reporting seeing half-dressed people in the park. That's not what we want for our city. That's not what I want for our young people. So those do typically result in a jail sentence, but most of them are suspended jail. And the suspended jail is suspended for 3 months, and at the 3-month period, they have to come in and show me, have they done their alcohol evaluation, have they done their community service, and if not, then they're looking at serving that jail sentence.
Well, Beth, I really appreciate, or Judge Padilla, I really appreciate just all the work you've done over the years and the great relationship you've built with Carla and what you guys have just really done with the municipal court. I think it shows that you are holding people accountable, whether they want to go through the system and get better or don't. It's, a matter of holding people accountable. And I think that really shows, so thank you.
Absolutely.
And thanks for updating us on everything that's going on.
Of course. Thank you. Any other questions?
Yeah, I just wanted to echo, I just always appreciate, I'm always excited for your updates and hearing more of your thinking outside the box, working with other communities, networking, and I just want to say good luck at your event, and that's really exciting that Cortez is hosting that. So
It is. So it's our second annual. We've now declared it annual. And there are 15 municipal courts that have been invited. I should also mention that Ms. Odell and I will be attending the Colorado Municipal Judges Association Conference in October. And that is specifically, the fall one is designed for judges and clerks. And that's a statewide conference. Again, an amazing networking opportunity to be able to meet with other judges and clerks and just have people to call when we get stuck. Okay.
Well, thanks so much for
Thank
your
you.
time.
Absolutely. Thank you.
All right, we're gonna move on to B on our agenda, an executive session for the evaluation of, our annual evaluation of Attorney Patrick Coleman. We'll need a motion on this.
Yeah. I'd like to make a motion to enter executive session for discussion of a personnel matter, specifically to conduct an annual performance review for Patrick Coleman, the Cortez City Attorney, and discuss possible amendments to Mr. Coleman's employment agreement as authorized by C.R.S. Section 24-64024F1. This executive session will not involve any specific employee who has requested discussion of the matter in open session, any member of this body or any other elected official, the appointment of any person to fill an office of this body or of any elected official, or personnel policies that do not require the discussion of matters personal to particular employees.
Second.
Motion made by Dobry and seconded by Lewis.
Kiefhoffer,
Aye.
Bill, Spruill,
Yes.
Dobry,
Aye.
Ben,
Aye.
Lewis,
Aye.
Medina.
Aye. All right. Okay, I gotta read this and then we'll do our council discussion. Okay, it is still July 9th, 2024, and the time is 7:20 p.m. The executive session has concluded and council is reconvened into open section. The persons participating in the executive session were myself, Mayor Rachel Medina, Mayor Pro Tem Lydia DeHaven, and council members Robert Dobry, Matthew Kiefhofer, April Randall, Dennis Spruill, and Bill Lewis. City Manager Drew Sanders and City Attorney Patrick Coleman were present for the start of the executive session, and Patrick Coleman rejoined the executive session at 6:32 p.m. and then re-exited at 7:04 p.m. No adoption of any proposed policy, position, resolution, rule, regulation, or formal action occurred during the executive session. If any member of council or a member of the public believes that the subject matter of the executive session was not statutorily authorized, or that the discussions that occurred in executive session strayed from the announcement subject matter, please speak up now. All right, seeing none, we will adjourn the special meeting and or we will move on to C on our agenda, which is the general council discussion. Does the council have, Councilmember Kiefhofer?
Madam Mayor, it is my understanding that there's still the possibility that within the city of Cortez that there is another medical or retail marijuana site. We currently have 7 retail dispensaries within the city of Cortez. And I know that there's some question around that in terms of whether or not there actually is the space. I believe that there is when you look at a map. And I would potentially like the support of city council to institute a moratorium. I believe that 7 stores is enough, and I think that what we've heard for the past 2 years is a huge decline in sales, and every single month when we get the revenue reports, that's what we see. And I'd much rather have something like that than 2 giant storefronts or 3 or whatever that would be vacant. So that's an idea that I would just like to float out there. While there hasn't been interest in an 8th location, that now might actually be the time to institute a moratorium.
Okay. I think part of that story too is we need to define, you know, what a school is, correct? Me if I'm wrong, city attorney? Because that was one of the, and then I see where you're coming from, because I think adding, flooding that market as well jeopardizes the existing businesses and the local businesses. And do we really need another one? And maybe we do, you know, where do we start that conversation then?
Yeah, and Madam Mayor, if I could interject a little, I think rather than structure it as a moratorium, you might want to look at amending the code with regards to marijuana. Currently, the only restriction that our code has with respect to number of marijuana dispensaries is the distance limitation. Some communities actually put a cap on the number of entities that can be approved. A moratorium generally has to be temporary in nature. It has to be a very refined, specific purpose, which could be to amend our marijuana regulation. But that's usually the reason for a moratorium, is to allow the local government to catch up with their regulatory process. But if you're just wanting to, it may be just as easy to amend the marijuana code as it is to adopt a moratorium regulation. You know, unless there's like an immediate pending urgency, we may want to consider just skipping the moratorium and actually looking at changing the regulation or the ordinance to adopt a cap.
Okay. Then how do we proceed with that, I guess? Add it to an agenda or a work session?
Yeah, I think if that would probably be an appropriate topic for a work session, and then staff can have direction as to, you know, what a draft ordinance might look at. And obviously, I want to discourage you from doing a moratorium if you think a moratorium can be done as a resolution, so it only takes one reading. An ordinance would take 2 readings. So if time is crucial, then the moratorium might be appropriate. Generally, moratoriums are, they encourage you to do it for maybe 6 months at the most. And then if you still have, you know, if it's like updating your master plan, sometimes that takes more than 6 months. So you can do an extension towards the end of the 6 months. But for something like this, I would certainly think that we could get an ordinance in place in less than 6 months.
So, yeah, I guess let's, on a future workshop, let's talk about the different approaches and ideas around this idea.
Okay.
Yeah, and I'd like to hear like information on what other communities do with caps and things like that, especially in the neighboring communities.
Well,
Yeah,
the
and
one
like-
I'm most intimately familiar with is Grand Junction. They have a limit of 10. And they're obviously quite a bit larger than we are. But they haven't had all 10 applications yet, is my understanding there.
Okay. Well, and we'll get
Yeah,
there.
I think
when-
it's, the market
at the
has
time. Yeah. Okay.
the need.
Thank you.
I'd just like to say that I think Councilman Kiefhofer's kind of wanting to know what the support of the council is, and I will say that I absolutely support the cap.
I agree.
Okay. Yeah, then that's a worthy future agenda item. Thank you. All right, any other topics to discuss? Okay, then we'll end the work session and we'll reconvene for our regular meeting at 7:30. Okay, at 7:33, we'll take 5-minute break. Thank you.